SJC-12836, Commonwealth versus Terence Tyler.
Okay, Attorney Reedy.
Good morning, Your Honors. May it please the court, my name is James Reedy, and I represent the defendant, Terence Tyler. Mr. Tyler participated in an attempted unarmed robbery that led to the shooting death of Wilna Parise. Because Tyler was not the shooter, and there was no evidence presented of malice, the Commonwealth proceeded under a felony murder theory. The central question at trial was whether Tyler acted with a conscious disregard for the risk to human life. In other words, the question was whether the robbery was planned in a way that ignored the likelihood that death would result.
You didn't bring an insufficiency of evidence claim on that.
I did not, because I think there is, I think clearly there is, the jury could have made that conclusion. However, given the jury instruction on conscious disregard, which provided the jury both an option to convict Mr. Tyler under a theory that only satisfies involuntary manslaughter, as well as satisfies the conscious disregard standard, I don't think this court can draw anything from that, from the jury's conclusion that he acted with a conscious disregard.
Well, you obviously fault the model instruction. The judge followed the model instruction.
Correct.
On conscious disregard. And one thing that permeates your appeal is kind of a blurring of the lines between the necessity of an involuntary manslaughter and the applicability of involuntary manslaughter in a felony murder case and this jury instruction. Aren't these separate inquiries?
I'd see, well, so they are, but I think that they have certainly overlapping themes and overlapping questions, right? If for the model jury instruction, if allowed the jury to make a conclusion that conscious disregard is satisfied by an act that's only dangerous to life, that could satisfy the involuntary manslaughter standard, which describes dangerous to life in the sense of a substantial risk of death. Now, obviously...
And we distinguish between them by degrees of harm, correct?
Correct. The risk is the distinguishing. Substantial risk of death would be involuntary manslaughter. Likelihood of death would be conscious disregard. Right. Given the facts of the case, given what the plan was, and there wasn't much of a question about what the plan was...
That's why I opened with sufficiency, right? Because I thought that was, and that was what basically was argued. And the lawyer obviously did a good job because convinced them that there was no, he didn't have knowledge of the firearm.
Correct.
Right, so, yeah, to me it was a close case, frankly.
I think it's...
Actually, it's a very close case.
It's a very close case, but I think it would be, frankly, a little disingenuous to argue that there wasn't sufficiency of the evidence in the sense that I think that the jury could have had a conclusion based on, I think, what the Commonwealth lays out in its brief, that the plan is involved a drug dealer, et cetera. But the jury also could have reached the opposite conclusion.
Sure.
And so that's why it's not a sufficiency of the evidence argument. It's more that the jury instruction didn't provide the jury with enough of a narrowing to ensure that jury came to the same conclusion.
What would a better jury instruction say?
Dangerous to life and likely to cause death.
Dangerous
It's the likelihood of death that is the distinguishing factor. The fact that the court uses the word or, the model jury instruction uses the word or, signals to the jury that dangerous to life is something that is less than a likelihood of death.
Dangerous to life, likely to cause death.
Dangerous to life and likely to cause death. And. That's exactly what the court said in Matchett. It's what came from Cerny, which is that English case, which is sort of the modern foundation of felony murder, which said that it has to be dangerous to life and likely in itself to cause death.
If that's what it said in Matchett, do you know how that came to be in the jury instructions?
I don't. There's no footnote in the jury instruction that says we're getting the language from here. It is simply says likely, dangerous to life or likely to cause death. And in my research, I couldn't find, there's no really discussion of it. And I'd suggest that that is probably because, anecdotally, most felony murder cases involve armed robbery or a handgun or an act that is inherently dangerous. And where an act is inherently dangerous, conscious disregard is presumed. It's not a question really for the jury. It's by law. There's a conscious disregard.
So post-Matchett, you try to track this down as to how this language...
I did, and I couldn't find anything. And I think that I didn't see anything in the murder, the model homicide instructions prior to 2013 The model jury instructions after 2013 track that language.
And they only cite match it, I assume?
There's no citation at all.
Okay.
In the, at least in 2013, I didn't find anything in, at least off the top of my head, I don't, because I think I would have gone down that rabbit hole if I did.
Okay.
And I did not. I couldn't track where that came from.
Can I ask you about the involuntary manslaughter
course.
instruction? The general rule, as you recognize, is that you don't get involuntary manslaughter in a felony murder case, period.
Correct.
Then there's Donovan and Campbell, which are the only exceptions, correct?
Correct.
In your reply brief, you circle back to the inherently dangerous language, but I don't
Correct.
think that's appropriate, because if you have to deal with constructive malice in felony murder, and when I read Donovan and Campbell, they're all instances where the felonious intent could be something different. In this case, you agree that the felonious intent was to steal, correct?
Yes, based upon the fact that defense counsel took that position.
Sure. Well, it'd be hard not
closing.
to.
It'd be hard not to.
Given
Agreed.
given it was his idea.
Agreed.
So,
Agreed.
So how do you get around the fact that you have a felonious intent, and the only felonious intent in this case, that matches the predicate felony, and in Campbell and in Donovan, there was evidence of different intent?
Well, let's go back to what Donovan was about. So in Donovan, the defendant was charged under two theories. Was charged under felony murder and was charged under conscious disregard. And it proceeded to trial under both of those theories. The court, upon a motion of the defendant, directed out the deliberate premeditation theory. So it only went forward under a felony murder theory. However, prior to directing that out, defense counsel had asked for an involuntary manslaughter instruction under the theory of voluntary manslaughter, which was denied and didn't matter at the time when it came to appeal, because the deliberate premeditation was directed out. The defendant specifically argued that involuntary manslaughter is a lesser included offense of felony murder. That's what the court decided. The court said specifically, we are deciding this as a lesser included offense, which is why they applied the substantial likelihood standard, because it wasn't a preserved error, because counsel at trial only asked for the involuntary manslaughter as a voluntary manslaughter under the voluntary manslaughter theory. It then said that involuntary where there is a question of whether the defendant acted with a conscious disregard, involuntary manslaughter can be a lesser included offense of felony murder.
No, it says when the defendant acted without malice, and what they should have said is constructive malice, but he acts with wanton and reckless disregard. You're reading in unfairly, I think, the conscious disregard standard. The facts in that case could have shown the defendant punched the victim, the defendant didn't know the juvenile defendant was armed, which is your case, basically, but then importantly, the defendant didn't know of robbery plans, and the defendant didn't participate in a robbery. That's not your case.
Agreed, that's not my case. However, I think that there is still a question of
On these facts, he could have been acquitted of felony murder because he did not share the co-defendant's intent to rob, and could have been convicted. That's what the court held. So the felonious intent on the facts could have been different as opposed to these facts.
But if we decide that it's the felonious intent that matters, and if you have a felonious intent and a death occurs during the commission of that felonious intent,
Right.
it is automatically felony murder.
Correct. That's why you don't know. That's why you don't get the instruction. That's the general rule.
Well,
You're trying to read out the general rule, and then to think it cites Campbell. Campbell, you've read Campbell. Campbell's that
course.
crazy, the factual, and they said, hey, as unbelievable as the defendant is, you take him at his word. And the guy gets on the witness stand and says, oh, I didn't rape her. She was, she was yelling. I put my hand on her throat, my hand slipped, and the next thing she wasn't moving, and then we undressed her and dumped her. So they said, where the predicate is assault with intent to rape, he gives this far-fetched but his story that it wasn't a rape, it was actually this accident. The court says, well, his intent could have been this crazy thing, so he gets involuntary manslaughter. Again, no felonious intent.
But if we have a felonious intent, we're essentially saying there's a bright line rule that if there's a felonious intent and a death occurs.
The predicate, yeah, the felonious intent being the predicate, importantly, the predicate felony for felony murder.
Correct, but there is also a recognition that someone can have a felonious intent, but not be involved in a plan that is likely to result in death. Because we have the two things.
That's a separate thing the government has to prove. So the issue is whether you get involuntary manslaughter. The whole purpose, which obviously post-Brown doesn't.
Right, it doesn't. It's,
right.
It's an academic, well, not for Mr. Tyler, but it's.
Not for Mr. Tyler,
right.
exactly. The point of felony murder pre-Brown was that constructive malice takes you out of malice, right?
Right.
Any of the prongs, so therefore we're only dealing with what did this defendant intend with respect to the charged felony, nothing else.
Well, except
An involuntary manslaughter, any manslaughter, negates the three prongs of malice because you don't have an intent to kill, etc. You have this wanton and reckless conduct.
agreed. So if the idea, in order to prove felony murder, the Commonwealth must still prove conscious disregard, obviously. They must still prove that,
Right.
as I
'Cause
phrased it, dangerous life.
And
unlikely
what
to
match it says is if we have someone who's a pickpocket and they're running away and they kill someone, we're not going to do this. We need, and you're absolutely true, right, that 90% of these cases, it's not an issue.
and that might be low. Yeah.
It might be low, you're right. That's why,
Well,
that's why I go to A, either sufficiency,
C.
or B, 33E.
Again, is it, all those who said it's Mr. Tyler, it's more of an academic question, but I find it difficult to fathom that that there is not a lesser included of felony murder in the sense that a death still occurs during the commission of a felony. But if that felony was wanton and reckless, there was a substantial risk of death, but not a likelihood of death, that without that likelihood of death, the act is still unpunished. And that's where, frankly, I think Donovan was trying to get to. I understand the court's reading, and I certainly don't think that that's an inaccurate reading.
No, it's
but I
not,
do think there's another.
The Commonwealth read it that way, too.
They did. But I think that
your way.
I do think that there's another possibility that there is something. There can be an act that results in death that doesn't involve a conscious disregard.
I do agree if it wasn't the charged predicate felony, if it wasn't a qualifying felony.
Well, it's a qualifying. I mean, any felony is a qualifying felony.
Well,
It's either first degree or second degree.
right.
And it depends on the sentence.
You're right. And the jury, of course, rejected the B&E. Can you address?
Well, maybe they didn't even reach the B&E.
Well,
Because it came back first degree.
Right, they had it as an option, they didn't pick it.
Well, because the defense counsel told the jury that he committed an attempted unarmed robbery, I think, which is a fairly significant concession.
Yeah, I think he was putting his eggs in the sufficiency basket, and it didn't work out.
So I disagree with that. I don't think he asked for second-degree murder if he's putting his eggs in a sufficiency basket. He asked for straight second-degree murder, not second-degree felony murder, straight second-degree murder. And that, to me, doesn't speak of a defense attorney who has a coherent strategy that I'm going for it all. I'm going for an insufficiency when I'm asking for a second degree.
Help me out as far as 33E goes?
Sure.
How would we analyze this under our 33E standard to get to a second degree?
I don't think you get to a second degree. If involuntary manslaughter is not a lesser included of felony murder.
Right, assume that, then I guess you're going all for nothing, so, right?
So that argument is based on the
It's a constant with justice standard.
Correct.
Right?
So,
but assume for sake of argument that I don't agree with you that involuntary manslaughter isn't at play. How do I get to a second degree constant with justice, where this was a very close case?
Well, I think, assuming also that the court doesn't make a decision that the jury instruction created an issue that required a remand. Given the fact that and I know it's different, but given the fact that the trial court found that there's no second or third prong malice, given the fact that there was no evidence from one can even find malice, at least as far as malice murder is concerned, under second or third prong, and also given what this court has said in Dawson about the validity of an involuntary manslaughter instruction when it comes to a death that occurs during the commission of a felony, and drawing a distinction between felony murder and involuntary manslaughter. Again, assuming that the court comes out the Commonwealth's way on the first argument, the evidence of this case speaks of just a dumb decision, but not one that was either intended or reasonably could be concluded would have resulted in a death. They were going into a house. It was a snatch and grab. They were expecting him to be, for lack of a better term, distracted, and in a position that he would not be able to physically react. There's two people involved. One grabs the marijuana, one grabs the cash, and they're out.
There was no evidence they knew that they thought he was armed as well.
There's no evidence that they thought he was armed. The Commonwealth makes a lot of the fact that he had two pit bulls, but I think one, there's not really evidence that the defendant knew they had pit bulls. Secondly, I think that really depends on the perception of what pit bulls
And the jury,
are. And the jury was told the pit bulls were kept in the room by the defense room. It said we kept those pit bulls in the room because they would be all over people when they came in the sense of they would be overly friendly and really kind of annoying. And that's why they kept them locked up, not because they were attack dogs.
and jury rejects the firearm knowledge.
The jury rejects the firearm, ultimately. There was no evidence that he would have known there was a firearm. The Commonwealth tried to make a trial to say, well, look at the way that Mr. Shepard is walking and that Mr. Tyler would have seen that. There's no, even in the video, there's no evidence that he saw it. They're moving sort of separately. It's dark. There is nothing in this case that speaks of that Mr. Tyler would have had a reasonable
Because
perception.
we don't have Brown, obviously, because he was there and he planned it. He's not on the outer fringes of the conspiracy.
He's not in the outer fringes of the conspiracy. And when I had the portion of the brief talking about the retroactivity of Brown, I was coming from the perspective of give the defendant an opportunity to demonstrate there is no malice. Not that there was no malice at trial, because I do think that balancing of how the Commonwealth would have proceeded is obviously important. But there was no evidence of malice regardless of how this case proceeded based on what the Commonwealth knew.
I mean, I'm trying, the basic position, I think, on 33 years, it's just unfair for him to do life without parole.
It is.
On these facts.
It is.
I mean, is that the bottom line?
That's the bottom line. That on these facts, given what he knew, given how the plan was supposed to go, given the lack of any evidence that the victim had a weapon or that he was not supposed to be able to react, that this wasn't supposed to involve any sort of confrontation whatsoever. And while we may think that it's not the best plan, it doesn't mean that it was a plan designed or even would have hinted at death. And it's fundamentally unfair for Mr. Tyler to spend life in prison, despite the fact that Mr. Priest tragically lost his life, for him to spend life in prison, to never leave those walls.
And I should know the answer to this, but can you tell me what happened with the co-defendant?
So Mr. Shepard was, surprisingly, also convicted of felony murder with unarmed robbery as the predicate felony.
In a separate trial, correct?
Separate trials, and I'd suggest, and I know this court's already heard Mr. Shepard's appeal, I would suggest that part of that has to do with the defense at the second trial. The defense at the second trial really focused on the idea that Ms. Jones could be the shooter. The way she was the person seen leaving, there was a woman who screamed, et cetera. And I'd suggest that jury's conclusion about Mr. Shepard was, we don't know if it was Mr. Shepard or Ms. Jones that was the shooter, but regardless, they both participated in an attempted unarmed robbery that resulted in a death along with Mr. Tyler. And there was no question whether Mr. Tyler was the shooter.
We resolved Mr. Shepard's case?
No, you heard Mr. Shepard's case approximately 6 weeks ago.
Okay.
Mostly that had to do with the application of the felony murder rule and systemic racial injustice.
all right.
But there was it was tried very differently. It was tried with the idea that it's not necessarily that Mr. Shepard was the shooter. There was also evidence that Ms. Jones was the shooter, and it suggests that's why the jury came back on the same with the same verdict, but they were tried very differently. And if there are no further questions from the court, I'd rest on the remainder of my arguments on my brief.
Thank you.
Thank you.
Okay, Attorney Jansen.
Morning, may it please the court. Catherine Jansen for the Commonwealth. I'd first like to address the jury instruction on conscious disregard, and I think it's important to look at what the actual standards are. For involuntary manslaughter, wanton and reckless conduct is a high degree of likelihood a substantial harm will result to another, whereas conscious disregard is the risk of loss of life. So,
Do you know how we got the or versus the and match it?
I'm not totally sure. I think under Match it was just citing, excuse me, the principle from England about what's necessary for conscious disregard. I don't think it's wedded to the and language, and I think the case law as it's developed from Match it talks about it being dangerous to life and a foreseeable risk of loss of life, and I would cite Cook, 419 Mass 195 at 205 through 207. It's a 1994 case, and that's again just articulating the standard. And I think when you're looking at, I think what the defense is essentially trying to argue is saying a likelihood of death. That's essentially third-pronged malice, which is a plain and substantial likelihood of death will result. So the degrees of risk are all different. And this case, in this court, discussed that in Snead, Commonwealth v. Snead. And so I would suggest that jury instruction with the or was appropriate. It was this court's instruction that told judges to use. It would have been reversible error to not use that. And of course, the defense attorney below did not object to that language at all. And I think where you have the dangerous to life or likely to cause death, the likely to cause death is more consistent with the third prong malice, but dangerous to life is another way of saying foreseeable risk of loss of life. And therefore, I think it adequately informs the jury of the amount of risk necessary for conscious disregard, and it's different from wanton and reckless conduct.
Why did your office agree in the motion for new trial on the involuntary manslaughter, lesser included?
Well, I think this area of law is admittedly complicated, and I think that the Commonwealth's position on appeal is the correct one under reading of Campbell and Donovan. And of course, this court under 33E is not bound, it has to review the whole record. It's not bound, obviously, by the Commonwealth's prior concessions, I guess I would say. And I think you hit the nail on the head under reading of Campbell and Donovan. There was evidence on the record that the defendant intended to do something other than a felony. And when you look at Donovan, the language you cited, it was that the jury could find the defendant didn't share the requisite felonious intent. And I think that's what we're looking at, whether involuntary manslaughter is required or not as an instruction.
Tell me why this is a life without parole case.
Sure. So first of all, I would argue that because the jury was instructed on conscious disregard appropriately, and I think these facts support that, in that, while they may have, and I understand the jury did not come back with armed robbery or armed home invasion, but that just suggests maybe they didn't find actual knowledge, but it doesn't mean that they didn't find that there was a reasonable possibility or probability that he was aware that Shepard was armed. And I think the fact that
we got a complete rejection of that theory.
Well, no, complete rejection of the theory of actual knowledge, which is what the Commonwealth was required to prove for the armed home invasion and armed robbery as a predicate.
I think you have an uphill battle, at least to convince me that
Understood, Your Honor.
That he knew a firearm was involved. So what I have is this foolish plan to distract him. They go in trying to get weed and money, and then bad things happen with a guy who thinks it's an unarmed robbery. And if I look at people who are doing life without parole, this doesn't match up well.
Well, I think when you look at the fact that this was going to be, you're going into a drug dealer's home late at night, and the case law is clear that you can, I don't want to say assume, but there's a high likelihood that you're going to be met with violent resistance in somebody's home, especially when drug dealing is involved, and that although I will admit there was no evidence, I believe, from Jones' testimony that he definitely is armed or.
Yeah, I mean, in Brown, we had, these are two tough guys, right? They both worked as bouncers, and there's a necessity to be armed to confront these two tough guys. We don't have any of that in this case, right?
Well, I do think, I know.
We have him as drug dealer.
We think of him. I think of him as drug dealer. I do think the fact that he has pit bulls, and say what you want about them, I think a reasonable person and from society might view pit bulls having a certain almost.
The dog in the Little Rascals was a pit bull, but that might be dating myself.
But also, I think you can't divorce the fact that, and I would point to Commonwealth v. Netto, and of course that was an armed robbery, but the court also talked about unarmed robbery, and if the defendant had gone in with the belief that it was going to be unarmed, that there was more than enough to warrant conscious disregard there, that you're going into somebody's house late at night and that they weren't welcome there. I think here the fact that the defendant knew that the plan wasn't going according to plan, that he wasn't indisposed.
Aren't all these, the things that you're talking about now go to whether or not a firearm would be involved?
Well, and I still do think, and I'm willing to say that the jury rejected actual knowledge, but I still think that they may have found, based on the video evidence from 8 Carlton Street, I can't remember the exhibit number because they were different between the two trials, I apologize, but that you can see the Shepherd manipulating something in his waistband, and you can see Tyler looking at him.
Right, so say we don't agree that because the jury did not find that he knew about the firearm. Say we don't agree with you. Is there anything else that you can point to that would suggest that he should get life without parole?
Well, I feel like the fact that he brought another person with him, even if, say, doesn't know about the firearm with Shepherd, the fact that he brought another person, Shepherd, the only reason why you would bring him is to help meet resistance, and I think the fact that you're, again, going in late at night, a drug dealer, you could assume that it might turn violent. And I think also the fact that he knew that the victim wasn't indisposed, and he went in anyway because there's evidence he was talking to Jones, and Jones was saying, wait, the plan's not going according to the plan, and he went in anyway. So I think those are important facts. And I understand the court's position about the firearm, but I would say there's a distinguishing fact about actual knowledge and what the jury rejected actual knowledge, and maybe that they thought that he thought there was a possibility that Shepherd might have been armed. But I understand the court's position on that, but that would be the Commonwealth's reading and why that would be appropriate in this case. The Commonwealth is happy to answer any additional questions or rest on its brief if there are none.